Hi, I'm attorney Chris Dumm, and thank you for making it to the last of our series of 5 videos on being a successor trustee. In this final session, let's talk about what does it mean to be a trustee after your loved one has passed away. When your loved one passes away, you may have several roles to fulfill. You may be the death trustee. You may be the personal representative. More than likely, you'll be a grieving family member with other grieving family members. You will also need to speak with probably an attorney, your accountant, financial advisor, insurance advisors. All the trusted advisors that your loved one had can be a resource to you. As a death trustee, you'll assume complete financial control of the assets that are in the trust. You should do an inventory, not just of the assets that are in the trust, but of all assets, no matter how they passed upon the death of your loved one. Remember that as you're the trustee, your duties are still bounded by their rule book and the instructions that are in their trust. You may also be the personal representative under your loved one's will. This means that you're going to be responsible for any assets that have to go through probate. Your loved one's will nominates you as the personal rep, but a judge would actually appoint you and give you your badge of authority so that you can probate assets that need to be probated. Also check the will to see who is nominated as guardians from any minor children, because they'll need to be notified and also be made a part of the probate proceeding. So, what do we do? First things first, get the red book, call your attorney's office. Don't sign anything, don't sell anything, don't give property away, don't close out bank accounts, don't distribute assets until after you have talked with your qualified estate planning professional. Okay, so now you're the death trustee. Your first duty may be to pay for the funeral. So you may be in charge of making some funeral arrangements, paying for that, making decisions on that. Please look in the red book for instructions on your loved one's final arrangements. You may need to contact relatives. You may need to contact close friends. They may be listed behind the Key Advisors tab or the Locations List tab. You'll want to notify the newspaper or make sure that the funeral director has the information so they can notify the newspaper. You'll want to get certified copies of the death certificate. You'll probably want to meet with your estate planning attorney. Look in the back of the red book for a personal property memorandum where it says, I want these specific pieces of property to go to these specific people. You'll want to try to find the safe deposit key so that you can get into the safe deposit box and the original will of your loved one may be in there. Make sure you take an independent third party with you because we don't want you to be falsely accused for stealing something out of the safe deposit box. You'll want to notify insurance companies, company personnel departments. You may want to notify the Social Security Administration. The funeral home will also have information on that as well. You'll probably want to notify different trusted advisors of your loved one. They may have important information for you. You may want to locate military papers. Notify utilities companies and any landlord. If you can, it's a good idea to run a credit report because that will help you identify the creditors of your loved ones so that you can send them letters to say, please shut down these accounts. Okay? So credit card companies, make sure you cancel those credit cards and also inquire about if there's any death benefit associated with a membership in that credit card company. You'll want to notify the post office. If you're the death trustee, it'd be a good idea to have your loved one's mail start coming to your address because one of your jobs as a trustee is to marshal or to get information on the assets and to take control of those assets. Make sure that as you start running the financial affairs of our client, your loved one, and you keep your expenses and your income and especially your bank accounts separate from yours, as well as if there's a surviving spouse. When someone passes away, their stuff needs to be separate. And that's something that probably should be discussed with your estate plan attorney and your accountant in your initial meeting with them. One of the first things they're going to tell you in that meeting is, okay, what's in the trust? And let's prove that it's in the trust, or let's locate and let's value all of the trust property. For certain property, we'll have to get an appraisal in order to determine what the value is. You're going to want to make an inventory of not just assets that are in the trust, but all assets that your loved one had an interest in. Please do not start distributing assets to the beneficiaries or to other people until you have reviewed the trust document and you've met with your trusted advisors. Make sure you discuss with your qualified estate planning attorney if a probate is necessary. Look for any business agreements on how that stock or that membership interest, if it's an LLC, is to be distributed or how it's to be sold or transferred. If your loved one died while they were on the job, there could be a workers' compensation type claim, or there could be a personal injury or wrongful death type claims that you'll want to discuss with your attorney. Make sure you cancel your loved one's driver's license as well as their voter registration. If your loved one had membership in some organization or had a continuing membership where they were paying so much a month to someone to be a member, make sure you cancel those. And then if you can, request a refund of any unearned membership fees. You'll want to contact your loved one's financial institutions, and they're probably going to ask you for a W-9 form with the new tax identification number for the estate or for the trust of your loved one when you do that. We'll want to do a new affidavit of trust or a new certificate of trust because there's probably a new trustee. If our client was a trustee and they've now passed away, obviously there's been a change of trustee and we'll need to have a new certificate to notify third parties of that. There could be transfers of assets to sub-trusts inside of the trust document of your loved one. You don't have to be good at this, but you do need to know if you're good at this. If you're not, let's get you some help, okay? Because remember, as a trustee, you have a fiduciary duty and you do not want to breach that, or you could be held personally liable. So we need to keep detailed financial records. Remember that whatever's coming into the trust is either identified as principal or as income, and sometimes identifying what is principal and what is income is due to a state statute or the State Principal and Income Act, and so your accountant and your attorney can help you with that. You also have a duty to inform beneficiaries. In the documents we create, it is not uncommon for us to say you have to let the beneficiary know what's happening, what's going on, at least once a year. You or your accountant needs to prepare 1040s for the person who has passed away. There may be another 1040 that needs to be done for the survivor if it was a married couple. There could be administrative trust, there could be family trust or marital trust, all these different types of entities that are created as a result of someone's passing, and there could be tax returns associated with that. This is kind of a diagram of how some of our clients have set up their estate plan. If they're a married couple, their trust may actually split into two different types of trusts and may have to have a continuing income tax return that is done. So you'll probably want to have an attorney or an accountant prepare if there's a federal estate tax return that's due. If the estate is of the person that's died is over 5.25 million, that's the number in 2013 that is indexed for inflation, so we anticipate that that number will continue to increase over time. If their estate is under that amount, but they were married at the time of their death, we may still want to file a federal estate tax return in order for the surviving spouse to elect portability of the unused part of their loved one's or of their spouse's estate tax exemption. And that's something that you should discuss in that first meeting with your estate plan attorney and the accountant. If there is an estate tax return due, it is due 9 months after the person passed away. It typically takes, once you file that, 5 to 18 months for the service to approve that. And keep in mind that unlike income tax returns, where they audit a percentage of all the filed income tax returns, every federal estate tax return is audited. You also need to have your accountant or attorney let you know if there's an state inheritance tax return that's due as well. So, once you've met with your attorney and your accountant, one of the things you should talk about is, can we distribute anything and when? And if they say yes, you can distribute, then we need to review the trust to find out how do we distribute that to the beneficiary. Does it go out right to them? Does it go to a HIM trust or a lifetime protective arrangement and then it's distributed when they attain certain ages? Or is it like in a lifetime trust for the beneficiary's benefit? And when I say HIM, I'm talking about HEM, health, education, and maintenance. And this is a type of an asset protection trust that says the distributions to this beneficiary are only for the health or the education or the maintenance of that beneficiary, not the health, education, or maintenance of creditors or predators. And we have a few listed there for you. An important item is also what records should you keep? Well, you should keep bank statements, brokerage statements. Make sure you keep canceled checks, deposit slips, copy of checks deposited, confirmation of things you've purchased or sales of securities. If anybody owes money or if you owe money, keep a track of the income and expenses of that, bills, invoices, receipts. Any correspondence that you have with beneficiaries should probably be in writing or at least confirmed in writing so that there's not misunderstandings later. There are times as a trustee when you can exercise your own discretion. When you do so, you'll want to document that so that someone knows that you were thoughtful, you decided which path to take, and you've documented why you chose that path. You'll want to, obviously not lose the rule book, the trust document, and you'll want to file and keep a record of tax returns. Remember, if you're called upon to be a death trustee, get the red book, call our office. Please don't sign anything, sell anything, transfer titles to anything, close bank accounts, or distribute anything before you have done so under the advice of counsel. Another important thing I want to make sure that we stress is all trustees have a fiduciary responsibility to the trust maker and also to the beneficiary. And that is not just the current beneficiary, but even future beneficiaries. So if there's property that goes into a trust that says take care of my child, and then when they die, take care of my grandchildren, you actually have a fiduciary duty to both generations. It's important that you follow the trust instructions and manage the property prudently. Remember from our past videos, you don't have to be perfect, but you do need to be prudent. Remember, you don't have to be a financial, legal, or accounting professional, but you do need to know when you need to hire one. Finally, I want to thank you for agreeing to be a successor trustee for our client. Our office is here to assist you in this challenging but very important role. If we can assist you in any way, please do not hesitate to give us a call. Thank you again for your time. and for your learning how to be an excellent successor trustee. Thank you.